Cameron Phillips is a Senior Associate at Ulrich Ruru and Associates, joins me now live for a discussion on this matter. Very good afternoon to you, Cameron. Thanks very much for your time. Just on the back of what Advocate Nugai Tobi said there, I have to start here. The issue here is perhaps less about whether and what alternatives are there, but the argument, in essence, is procedural, is procedure. In other words, the argument that is that here is that the hike was adopted without proper parliamentary oversight or proper procedures being followed. Am I correct?
Afternoon, Voya. Firstly, thank you very much for having me. You're quite correct. And I think what's important to really start off with is the actual premise of the two applications before this court. The application by the DA is founded in two parts, Part A and Part B, with Part B relating to the constitutional challenge to Section 7(4) of the VAT Act. But Part A of this application is this urgent interim interdict that's currently serving before the court. The EFF's application is seeking a similar order, but also seeks to intervene in the main application sought by the DA.
What, though, will they have to prove in both those instances for them to stand a chance of seeing their application succeeding?
Well, you would have heard me refer to the fact that they're seeking an interim interdict, and the interim interdict that they're seeking is 2 points, really. One, that they're seeking the setting aside of the adoption of the framework, which has been recommended or which has been adopted by the National Assembly. And two, the suspending the operation of the Commissioner of SARS ability to collect on the increased VAT. Now, what they are seeking is in the form of an interim interdict. And on an urgent basis to seek an interim interdict, there are 4 requirements which have to be clearly met and made out before the court. The first one being a prima facie right open to some doubt, a well-grounded apprehension of irreparable harm, the balance of convenience in favor of the applicant, and a lack of suitable alternative remedies available to the applicant.